So before we get started, I just want to thank you all for being here today. And so my name is Emily Kile. We're going to talk today about estate planning, trusts, powers of attorney, probate matters. If you have questions, please make sure that you type them into the Q&A or in the chat box, and I will do my best to take breaks and check and see what anybody has asked. And if you have any questions afterwards, please reach out to us and I'm happy to answer the questions for you. So again, Emily Kile, and we're going to get started here on our presentation on estate planning. So thank you all very much. So let's just kind of start with the basics of what is an estate. So it is everything that you own, whether that's your home, whether that's other real estate, bank accounts, investments, retirement benefits that you may have, whether directly or through your employer, insurance policies, your personal possessions and personal belongings, your vehicles, all of that stuff is your estate. So sometimes people will tell me, well, I don't have an estate. Well, you must have an estate because if you have anything, you have an estate regardless of what the size is. So then the question is, do we have to do some plan in order to best manage that estate or your stuff, as I like to call it? So most people want to make sure that they do planning because they want to ensure that where their stuff goes is where they wanted it to go after they pass away, so that there's some control over who receives the assets and how they get those assets, who's in control of them. Maybe you have minors that are going to receive money and you want somebody else to control that money or asset until they receive it. And of course, people are always concerned about legal fees. So they want to do some planning to try and maximize the assets for their beneficiaries and reduce whatever the legal fees or taxes might be. Now, for most people, taxes, at least estate taxes, are not a big concern. Right now, the estate tax exemption is just over $11.5 million per person. So that's how much money you could leave behind without the payment of an estate tax. There may be some income taxes due on the funds that you leave. For example, if you have an IRA that's not a Roth IRA, there might be some income tax to the beneficiary of that plan. And of course, tax rules are always changing with each administration that comes in. So what they will be when you pass away is really, really, really hard to predict. So in part, putting together a plan that has some flexibility so that we can deal with those issues is important. Now, the other reason to do planning, though, deals with when you're incapacitated. So people don't think of estate planning about what happens when they're alive but incapacitated. But remember that your powers of attorney are part of your estate plan. So you would want to make sure that there is a financial power of attorney, for example, for that would be the document potentially for somebody to manage and control your assets, pay your bills, make investment decisions for you in the event that you were incapacitated. And the same for making medical decisions. So for somebody to deal with your healthcare power of attorney to make those decisions while you're living but incapacitated. And all of that is part of your estate plan, even though most people think about their estate plan as just kind of where their money's going to go when they die. It's much more broad than that. So when we're putting together your estate plan, we want to think about how we're going to take care of you during your life when you become incapacitated. What about a surviving spouse, or maybe to provide some support or direction for your adult or minor children or disabled children or other disabled beneficiaries, or charities where you want to make sure that those charities are supported. And for charitable planning, you might want to have a specific goal. You know, if it's for animals that you want it for their spay and neuter program, or if it's to go to a university to a particular department. So you want to think about what those goals might be. And of course, most of us want to make sure we maintain as much control over our stuff, our property, as we can while we're alive and able. And who you pick is that legacy to make sure that you've chosen somebody who has your same philosophy, whether that's about healthcare decisions, um, physician intervention, or investment decisions, whether they're your investment choices would be high risk or low risk, conservative, whether it's income driven. All of those things go into making sure that we're going to meet your goals, that we have the right people in place to help make the right decisions. So it's very important that you think that through. Who do I want to make those choices? Are all your kids the right pick? Is your spouse the right choice? Maybe you have a brother or a sister who's a good choice. Maybe you have a friend who's an accountant who you're close to, and you feel that that would be a really good person to be making those financial decisions for you. So don't just pick your oldest child and put them in order of age unless that's actually what makes sense for your planning needs. So it might sound silly that I think that everybody needs an estate plan, and of course, I do estate planning, and as an attorney, so I have maybe a vested interest in you deciding to move forward. But I really do think that everybody needs to have some kind of estate planning. Some of them may be more complicated than others, but they're all really important. Perhaps the older you get, the more you're thinking about transfer of wealth to your grown children or preserving your wealth to make sure that you have enough money to pay for long-term care costs or a caregiver if that was something that was needed in the future. But if you have young kids, you want to think about, who is going to take care of them if something happens to me? Who should the guardian be for those young kids or those disabled kids? Or maybe you have a disabled spouse and you want to make sure that you nominate who a successor guardian should be for that person. Even if you're single, regardless of age, and maybe more importantly, because the default might not be what you want to be able to plan for where your stuff goes and who's going to make decisions for you. So, estate planning is definitely not just for people who are wealthy, but it's for everybody so that we can understand what your goals are and make sure to the best of our ability that they get followed. One question that people sometimes ask me is, can I leave behind a set of instructions and how legally binding is that? And you can always leave behind a set of instructions. I like to call that a memo of intent. And so if you have a particular doctor that you want to follow you, or you believe in some kind of treatment, or you don't believe in some kind of treatment, whatever those goals are, to put that forth in that memo of intent so the next person who's taking over knows to follow along with that same treatment plan. If it's important to you to stay home, and only if it's not affordable for you to be moved to some kind of a facility or out of your home to get care, that can certainly be in your healthcare document or again in a memo of intent. Your estate planning is not a contract with anybody, so it's an expression of your goals. Somebody else could see the document and say, hey, you as the agent aren't following through, and get that in front of a court to make sure it gets followed. But remember, it's an expression of your wishes. So again, who you pick becomes so important. So we can know that the person you've chosen is somebody who will follow your goals and understands the importance of them. So, in terms of when you should plan, the answer would be now. We don't want to wait until the bad thing happens because we might not have the ability to plan at that point anymore, right? So, in some ways, you're racing against the clock. You don't want to wait and say, well, I'm not going to deal with my mental health power of attorney until it turns out that I have an issue where I need to go into a psychiatric hospital, because by that point, you probably don't have the capacity to sign that mental health power of attorney. So the other thing to think about is we don't know when there's a tomorrow, right? I think that we all expect to have a long, healthy life, but sometimes bad things happen in a blink of an eye. So having something in place, understanding that you can change it at any time, you can update it whenever you want to. For the most part, all of the documents are revocable or amendable. So if you change your mind and picked one person to be your decision maker now or your beneficiary now, you always have the authority to change that in the future, again, assuming that you have capacity to do so. So getting things done sooner rather than later would be a good step. So let's look at some common planning ideas. Um, I would say I think the statistics are something like 75% of Americans have no plan, the no plan, and we have statutes that will fill in the blanks for many of the decisions, but often that's not really what you want. For example, we don't have a fill in the blank for financial decision making. So if you don't have a financial power of attorney or the account or asset is not joint where somebody else can access it, then we're going to end up typically in front of the judge to have a conservatorship started, which is a court action for somebody to make financial decisions for you. But for healthcare decisions, we do have a default. So that would be your spouse. It would be a majority of your kids, the person you live with, your closest heir. It sort of goes down a list, but that might not be who you want. Maybe you don't want your kids to be your decision makers. Maybe you need somebody else to be the decision maker, or maybe you don't have any people in that line of priority. And so having documents will be important. The same thing for inheritance. We have a statute, our intestate statutes, that tell us where your stuff will go if you pass away. But again, that might not be your choice. You might not want all of your stuff to go equally between your children. Or if you don't have kids, you don't want it to go to your siblings. So the nothing plan might get us somewhere, but it might not be where you wanted it to go. Joint ownership, remember that what the last man standing on the account gets the whole thing. So if you have a joint bank account with somebody and you, let's say, have your oldest daughter on there for convenience, understand that joint ownership means that that daughter will receive everything that's in the account. Now, she may make distributions out to her siblings, but she probably doesn't have a legal obligation to do so. So you want to be really conscientious about how things are titled. Maybe you want her to have signing authority, but not be the joint owner. So we're going to go into a little bit more detail on each of these things, but these are the general ways in which you can set up a plan. The other thing is remember about beneficiary designations. Those will take precedence over a will or a trust. So if I have a life insurance policy and I name my niece on there as the beneficiary, and then I say that in my will that everything goes equally between my nieces and nephews, she's going to get the whole life insurance policy because she was the named beneficiary, and she's going to get a percentage of the rest of my estate because she is in the category of people who would inherit. So again, just be mindful and thoughtful about how you set up your accounts entitling and how you would set up any beneficiary designations. So let's start with the will-based plan. And so you're probably aware that in a will, you can name who's going to deal with your financial affairs. We call that person in Arizona your personal representative. In some states, we call that person your executor. Remember that your will only control assets that are only titled in your name when you pass away. So it's an expression of your wishes, but it's only as to the assets that are solely in your name, not joint with anybody else, no beneficiary designation, and not titled to a trust. Those are the assets that pass through your will. So you might have a whole host of other assets that will never, ever go through your will at any time. So the other thing about a will is most of the time it's going to control assets, at least in the probate process, that are over a certain financial amount. But let me give you some examples. As I said before, if I have a will and it names all 5 of my nieces and nephews as the beneficiaries, but I had a life insurance policy with one niece on there. She gets that whole life insurance policy. That asset isn't part of my will. It doesn't go through probate. And having a will doesn't mean that you avoid probate. A will is just an expression of my assets that are subject to probate. How do I want those assets to be distributed? And who do I want to have the control to make those distributions? So I want to be really clear about that. Having a will does not mean that you avoid probate. You might not want to avoid probate. We're going to talk about that next. But just having a will is not a probate avoidance tool. Wills can be, fancy. They can be straightforward. They can be short. They can be long. They have to have two witnesses in Arizona. They don't have to have a notary. We like a notary because it says that you're really the person who signed it, but they have to have two witnesses. If you have one witness and a notary, and as long as they're different people, then that will count as your two witnesses. You can do a handwritten will called a holographic will. But you have to make sure that all the dispositive provisions are in your handwriting. So if you're filling out a form, you want to make sure that the bits about who the personal representative is and who gets your stuff is literally in your handwriting, not typed. And then make sure it's dated and make sure you sign it. We've seen lots of wills, form wills, where the person who made the will forgot to sign it. So you have to sign it, has to have two witnesses. If it's in your handwriting, we don't have to have any witnesses. I would recommend that you have witnesses so that there's no question that other people saw you do this, that somebody else didn't write this will for you, but it's not required by statute. So let's talk about probate for a minute, because I think it helps to frame the understanding of what the process is, what it is you think you're trying to avoid. So probate is the process of taking a will and having a court say that it is a valid will. Or if there's no will, that you are whoever are the valid heirs of that estate, and who is going to be in charge of making the distributions, who's going to be appointed as the personal representative, and whether or not a bond, an insurance policy over that person is required to ensure that the assets are distributed appropriately. In Arizona, we have formal probates and we have informal probates, and we have actually court supervised probates. So if you have an original will, meaning pen to paper will, and it has, it's valid, it's got two witnesses, says who's going to get the stuff, says who the personal representative will be, and there's no bond required. We do that on an informal process, meaning that we submit everything to the clerk and we probably don't ever have to see the judge. We have informal probates when there's no will at all, not even a copy, and everybody agrees as to who's going to be the personal representative and waives the bond. Then we have formal probates when we have a copy of a will and we can't locate the original, when there's disagreement amongst the parties, or if there's no will but people can't agree as to who the personal representative is or the waiver of the bond. All of that means that formal is more expensive than informal. Formal requires a court hearing and informal does not. Part of the purpose of informal or not is to make sure that it is a valid will and that we understand who's in charge, who's going to be the personal representative, who's going to be in charge of paying the debts, making the distributions, doing the accounting, and then filing your closing statement with the court. So you need to do a probate if the value of the assets is more than $75,000, or if it's real estate that the equity is more than $100,000. When I say $75,000, I'm again talking about assets that don't have a beneficiary, are not titled in a trust, and do not have a joint owner. And then we're going to add up all of those other accounts. So let's say there's CDs and there's stocks and bonds and there's a cash account. We're going to add up all that stuff together. And if it's more than $75,000, we are going to open the probate. If it's less than $75,000, We can do what's called an affidavit to collect personal property, it's called, or a small estate affidavit, or an affidavit to collect real estate. And each one of those has kind of a slightly different process and a little bit of different timing if we don't have to do the probate. But for real estate, if we're not opening a probate, we have to wait 6 months before we can file that affidavit. And so sometimes people want to open a probate because they don't want to hold on to the real estate and not be able to market it for that 6 month time period. We also might need a probate if people are fighting, right? So if there's a contest about who the personal representative should be, or somebody thinks that it's being handled improperly, then if there are contesting parties, we might have to have a probate. And again, only a probate when we have assets where we don't know who's supposed to get it by operation of law. But having said that, there still might be a probate when there are when there are minimal assets, because there's fighting amongst people. Somebody thinks that it was undue influence, and that's why somebody else is the beneficiary of all the accounts. So you still might have a probate even in a small estate situation, but it's not required. So what's the timing? So you can open a probate within 5 days after the person has passed away. In Arizona, we have to close a probate within 2 years of the date it's opened or file a status report with the court to explain why it's taking us so long. That should give you some understanding that the goal of probate is not for it to languish, but it's for it to get taken care of, for the debts to be paid, for the taxes to get filed, for the assets to be distributed, and then to close things. There are times when it will take us longer, maybe a piece of real estate that isn't being sold and the beneficiaries don't want us to do a deed and just distribute it out so they all have an equal share of it. There might be complicated business assets that are taking some time to deal with, or there might be fighting. And sometimes when beneficiaries fight, that's going to take some time before we can figure out how to make the distributions. But the goal is to get it closed within no more than 2 years. And as I said, if you have an original will, we don't ever have to see the judge. So everything's done through the clerk's office. They take about 3 to 5 days after we file everything to get what are called the letters of appointment issued, which is to allow the personal representative to start to deal with the estate. So as I said, the probate process is to make sure that it is a valid will or that there is no will. And the probate process is going to have some cost, but honestly, probate is not very expensive in Arizona. You're going to pay something if you use an attorney to do the probate, and maybe the cost depends on what the value of the estate is. That depends on the attorney who's doing the work for you. The filing fee, though, is only like $200. So from the court's perspective, it's not an expensive process. There is some time, of course, that needs to be put into that. And as I said, you're not going to open your probate until 5 days after the person died. But typically, you're not going to do that for trust administration either. It takes some time to gather information, get information about who the beneficiaries and heirs are, and you have to notice everybody in a probate and in a trust administration. So the nice thing about probate, one of the positives is that we publish for creditors. So we don't have to worry later that somebody didn't get paid out there in the world and the statute of limitations didn't start to run. So sometimes there are some benefits to doing a probate process and not a different process or no process at all through the small estate administration process. So one of the things about wills is also you can nominate a guardian in a will. So that's for minor children, disabled children, or a spouse. So you can say who should be the guardian in the event that you're not there to take care of that person anymore. In a will, you can create subtrusts. It's not as administratively clean as doing just a trust and then creating the trust for those minor or disabled beneficiaries or beneficiaries that you don't want to get the money right away. You can do it in a will. You can create special needs trusts in a will. Again, not my favorite avenue to go down. It's not as administratively clean. but it certainly can happen. So you can get everything you need in a will. The more complicated your situation, the more I would encourage you to do a trust, just because it's really the right way to do that more complicated planning. But it can be done in a will. As I said, you can do the do nothing plan, which 75% of your friends and family are in. Not the end of the world, but definitely not perfect. We're going to probably have a probate, whether it's formal or informal, unless you've put beneficiary designations on everything. Remember that beneficiary designations go to those people. So if you own a house, but you've put a beneficiary designation on everything, they're all going to have to contribute back to keep the utilities on until the property can get sold. Probably contribute back to make sure your final tax return can get filed. So it's not always the best plan to avoid probate by having a beneficiary designation on everything, because it doesn't give us any cash to work with to do the other things that we need to do. Also, remember, if not all your kids are in common, the statute basically says that you get to keep your half of the community assets, but the other half go to the children of that are not in common with you. Well, that can be a pretty big blow to lose half of your community assets. So you definitely want to think about having a plan in the event that this is a second marriage and you do not have all of the children from the same relationship. And remember that in capacity, we might have to have a guardian or conservator appointed. A guardian we can nominate in your will or in a separate document. But if for a conservatorship, we absolutely need to have court. You can nominate the person, but they're not going to get appointed until the court appoints them through the regular process. So our friend James Dean, who we've been talking about for a very, 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 very long time in our history as estate planning people, had the do nothing plan. And he was a young man, he was 29. He wasn't anticipating passing away particularly so suddenly. But this would be one of those situations where he probably would not have chosen the do nothing plan if he had understood it better, because his dad apparently ended up getting his license rights, even though they were not close. Now, there are some exceptions for a parent who abandons a child where they may still be disinherited even in the do nothing plan. But I would definitely not rely on that. So you want to have a plan so you know that your stuff is going to go where you want your stuff to go. So let's talk about joint ownership next. And I haven't seen any questions come in, so I'm hopeful that I'm just answering all of your questions so well. But if you do, put them in the chat box and I'm happy to answer them. So joint ownership, as I said, last man standing gets all the money. So if we have joint ownership between husband and wife, mother and daughter, father and son, whoever is the joint owner is going to end up receiving the funds that are remaining in that account. Now, sometimes when we also do a will, we make it clear in the will that the joint ownership was for convenience only and request that that money become part of the probate. If there's a contest, probably the court would agree and bring those funds in from the joint ownership that it was done for convenience only, meaning that you wanted to make sure somebody was going to have access to money to pay your final bills, but you didn't intend for them to receive all the money. By the same token, you could make them a signer on the account and so that they could access the funds without being an actual owner. So again, just be thoughtful about how you're titling assets. So, as an example, here we have Tom and Ann. They're joint owners. Tom dies, Ann gets everything. And then Ann dies, and it all goes to whoever it is that Ann wanted it to go to. So let's say that maybe what happens after Tom dies is that Ann remarries. And so now we have a situation where Ann's remarried, and so she then dies, and now her new spouse inherits everything. and he decides he doesn't want to leave money to Anne's kids, only he wants to leave money to Anne and Dan's kids. Also, think about it in these terms where you have a will that says it's going to go 50% to your sister and 50% to your husband's brother. And then again, whoever dies first gets all of the money, and then their will controls. And maybe they're going to change it after you're gone to say that it all goes to their side of the family. You can do contracts to say that you can't change your will unless I agree. You have to have a separate agreement, separate contract, and it has to be referenced in the will. Otherwise, joint ownership or in a will, if you leave everything to somebody else, they're going to have the control as to what to do with that asset when they have all of the money. So obviously, we want to give special consideration to those second marriages, third marriages, whatever. Basically, when all the kids aren't in common or you have different estate planning goals, or maybe there are some special needs beneficiaries in your family. And so you want to make sure we're taking care of them. So we want to look for, unintentionally disinheriting somebody, and we want to look out for unintentionally leaving stuff to somebody that we didn't intend to receive in the first place. When I say incapacity and court interference, if you don't have a power of attorney, then we might end up, as I said, with this conservatorship, and therefore somebody else who maybe wasn't your first choice may become the person who is managing your assets. You can't remove a joint owner unless they agree. So if you add your kid or somebody else on as a co-owner of your account, your boyfriend, your girlfriend, whoever, they would have to sign off in order to be removed as that co-owner. You can't just take them out. The other thing about joint ownership is you may have made your account now accessible to the debts of that joint owner. If there's a lawsuit or a bankruptcy of that joint owner, then the court's going to want to maybe put their fingers in to get that money out because you've given them an ownership interest. That would also be potentially true in the event of a divorce. So you've put your kid on there as a joint owner, they get divorced, and now their divorcing spouse says, well, wait a second, there's a joint account here. 50% of that maybe should be part of that divorce proceeding. Now, it might not. You might be able to prove that it's sole and separate. You might be able to prove it's all your money, and none of it was supposed to be your kid's money. But all I'm telling you is you may have muddied the water, and it may make it more difficult, or you may have a situation you hadn't anticipated just based on the titling of the account. So let's talk a little bit about revocable trusts. So most trusts that we do for estate planning are revocable, meaning that you have the ability during your lifetime to make changes to the trust. And so you have control. You decide that you don't like your beneficiaries anymore or who you put down to be the successor trustee. You have the authority to make those changes. We do trusts regardless of how much money somebody has, based on what their situation is, based on the complexity of how the money is going to go out, or sometimes not even the complexity, but just because it is a more robust plan, and it will allow for the management of those funds, again, on incapacity or death without having to file anything with the court. One of the things that's really crucially important, though, when you have a trust is that you have to fund the trust. So what does that mean? So you fund a trust, meaning that the ownership, the name on the accounts, the name on the assets, the name on the deed to the real estate is the trust. So instead of it being Emily Kile, it's the Kile Family Trust, Emily Kile as trustee. And so if something happens to me, it's still in it's still in the little buggy that I showed you on the last slide. So those assets are still within the carriage, right? They're all in there. It's just a question of who's pulling it around town, who has control and gets to dip their hand in and decide who gets the car or how we're going to spend the money, who gets to go on vacation on the yacht, those sorts of things. So that's funding the trust. And your attorney typically can't do that for you. They may assist you, but I can't go to your bank and change title to your accounts. And you wouldn't want me to have the authority to change title to your accounts. So, you might have a form to fill out to make that happen, but you're going to have to sign off on that. You can also have the trust be a beneficiary, like for life insurance or for retirement accounts, so that the funds during your lifetime are yours and then they funnel into your trust at the time that you pass away. Because retirement accounts cannot be titled in a trust while the owner is alive. So if I'm the one making the money and it's my 401k or IRA, even if I have a trust, that account ownership wise is going to remain in my name. But when I die, certainly the trust can be the beneficiary of that account. So again, think of it as a funnel. So the goal is to get those assets retitled into the trust or to be the beneficiaries. And then for all of those assets that are titled to the trust or have a beneficiary, we're not going to end up in the probate process because we already know where everything needs to go. I don't need a court to appoint the trustee, the one who makes the distributions, because it's already set forth in your trust document as to what's going to happen and who it is that is named as the trustee. So let me just give you a couple of words. So the trustee is the one who manages the assets and pays the bills. The trustor, sometimes called a grantor or a settlor or a trust maker, is you. It's your money and you're the creator of the trust. And then the beneficiaries are, of course, the ones who get to benefit from the stuff in the trust. So during your lifetime, you're probably all of those things. When you become incapacitated, you're still the grantor or the trustor. You're still the beneficiary. All the money's still there to take care of you, but you're probably not the trustee anymore. You're not the one to control how the assets are invested and paying bills because you're incapacitated. So you wear different hats, just like you might be a dad and an uncle and a son and a brother. Those are different hats you wear. The same thing in estate planning. You're just wearing different hats for different roles. So I had a super interesting question from a client, and I felt that I had clearly missed the mark. So they had a concern that if they did the trust, they would lose control because the trustee would then make all the decisions. Remember, your revocable trust, you can be the trustee. And so you still have control over all of your assets. Buy stuff, sell stuff, give it away, make gifts, take care of your kids, give to charity. You still have total control over all of those things. And for the most part, we put a provision in that says you can revoke or change it anytime you want to. Now, if you're married, we might say that both of you have to agree. You don't want your spouse to be able to disinherit you and not tell you about it. You probably don't want them to be able to change the trustee unless you say it's okay. But maybe you do. It might become irrevocable when one of you dies, or it might become irrevocable, meaning no more changes after the second one of you dies. So those are instructions that are going to go in the document, but it's how you want it to be drafted is the way it's going to be put together. So you still have control over what's happening. And of course, it contains your instructions for who's in control and who gets to benefit, who doesn't get to benefit, and how they get to benefit. Is all the money today, or is some of the money when you reach certain ages or meet certain milestones? So you get to control that inheritance for that person. And so you might decide, as I said, they shouldn't get it all at once. Maybe there are some issues with that person that you want to make sure that they get just the income from it, and somebody else is going to distribute principal, or they get 10%, or they get an allowance. You can do it in installments, whether that's at ages or they reach milestones. As I said, you can say it's just the income, Or you can say they get all of it. When you die, they get their percentage, and that's the end, and they get their money, and they can deal with it in any way they want to. There we go. So let me see. I had one question. It says I have a beneficiary designation on my home in 3 children's names. If I become unable to live on my own, is my home seized to pay nursing home costs? So that's really a long-term care planning question. So you can do a beneficiary deed for a house for real estate in Arizona. And so that's a deed that says, when I die, this is where my house is going to go, and there's no probate. So now all 3 kids in this example would have an equal ownership interest in the property. The question about whether it would be seized for nursing home costs is, the answer is nothing gets seized. The question is, does it need to be sold to pay for your care? Or are you going to use long-term care insurance? Or can you qualify for all tax benefits for our Medicaid program, the Arizona Long-Term Care System? And Altex doesn't seize your property. If you still own the house and you're a single person and you were in a nursing home, then the state would have a right to put a lien against the house and may collect when you die, not during your lifetime. If you never were in a nursing home for 90 or more days and there's a beneficiary deed recorded against the property, then most likely the state, even if you're on all tax benefits, will not get paid back from the house, because they do not have that kind of estate recovery right if there's a beneficiary deed that's recorded during your lifetime. Now, the rules could change in the future, but it's unlikely in that scenario that there would be a recovery by the state. So I hope that was helpful in answering the question. Something else you might want to think about in terms of a trust and controlling the inheritance is if you have beneficiaries who have special needs, developmental disabilities, Alzheimer's, dementia, whatever it might be, and you want to really control how they get money and to make sure they're not going to lose those public benefits that they need for other basic needs, so that you can control the inheritance in a special needs trust. And so again, maybe it's just supplemental income you want to give to the beneficiary, or wait until they reach certain ages, particularly, for disabled or minor folks, or I should say incapacitated or minor folks. And also remember that you can use a trust to protect the funds from what I would call creditors and predators, or divorce. So while it's in the trust and the trustee doesn't have an obligation to make that distribution, the assets that remain in the trust should not be reachable by the creditors of that beneficiary. So while I'm alive, even if my kids are named beneficiaries, their creditors can't come after my money. It's still my money. Those creditors have no right. Let's say I die and I've left money to one of my kids and they're in the middle of a bankruptcy and I did an outright distribution. Well, they're entitled to the money, and now those funds are going to be subject to the bankruptcy rules. Well, what if I set up a trust and I said instead that the funds are held in trust and the beneficiary has discretion about making distributions? Well, then it shouldn't be subject to the bankruptcy court, because the trustee is going to say, I'm not making any distributions, or I'm going to pay directly for services and not actually give the money. So there are lots of ways you can add some control. All of that, of course, adds more administrative time and expense at the time that you pass away, but it may be well worth it, or it may not. Those are decisions for you to make based on your own circumstances. So let's kind of just review what trusts do and don't do, I guess. So anything titled to the trust should avoid probate at death, unless, of course, we have fights. Fights end up in front of a probate court, regardless of titling, sometimes when there's a dispute. Most likely, we're not going to have court control of the assets at incapacity, because the successor trustee can take over. But having said that, If you've only named your spouse and your spouse is deceased or also incapacitated, we're still going to end up in court probably unless your trust says how we pick a successor trustee. So you probably want to have more than one. For the most part, you're going to have privacy, but we do have to provide notice when the trust becomes irrevocable and on your death to the beneficiaries. They have a right to understand how the funds are being used to protect their interests and would be typically entitled to accountings and an inventory to understand that they're getting their share of the estate that they were entitled to, and that they get a copy at least of the provision of the trust that deals with them. So we talked about those third parties, those creditors and predators. So you can use a trust to protect against those, but it's important to make sure that the title of the asset is in the trust. If you do an outright distribution from the trust, which is fine and probably 99% of the time what happens, once the asset leaves the trust, it is not protected from those predators and creditors. And of course, you don't want to avoid giving to people that you wanted to get your assets. And we can make it as flexible as you want in terms of what those distributions are going to look like. So let's take a few minutes to talk about power of attorney documents. So we have healthcare powers of attorney and we have financial powers of attorney. There might also be a mental health power of attorney. Your financial power of attorney might be called a durable power of attorney. That just means it stays in effect after incapacity. Powers of attorney to me are so important, maybe more important than your will, because this is about how we take care of you when you're alive. For the most part, your will is and your trust is about where your stuff goes when you die. Now, that might be important because you might have beneficiaries who are on public benefits, and we don't want to throw them off of public benefits by having that inheritance. But my goal of planning is about you. So, powers of attorney tell us how we take care of you while you're alive. So, powers of attorney for financial matters are to deal with money and benefits. And as from that last question, to allow us to do some planning, maybe for all techs, to say that we can make gifts of your money to your spouse or to your kids in order to get you on benefits and maybe preserve some money for the things that Alltex doesn't cover, like eyeglasses and dental care and hearing aids. And then also for healthcare documents to express what your wishes are so that the doctor has somebody to turn to help make those decisions and to avoid, of course, going to court and having some stranger maybe appointed to be your healthcare agent or your financial agent. So people think of medical decisions as just the living will for end of life decisions. Sometimes that's called an advanced healthcare directive. But remember that it's all kinds of medical decisions. You know, it's about ongoing treatment. It's about you're in an accident and somebody has to authorize treatment, or you're incapacitated and you need penicillin because you have strep throat. I mean, it could be a whole host of decisions that need to be made. We want to make sure we have a HIPAA authorization so the person can get access to your actual healthcare information and not be stymied by that. Healthcare documents only require a witness or a notary. So I'm going to give you where you can get some of these for free. So you don't often hear from the attorney as to where it is you can find free documents, but you can go to the Attorney General's website and look for the Life Care Planning Kit, which oddly is under the tab for seniors, even though it's for anybody over age 18. And it has all of these documents. So very useful. They're fillable, so you can fill them in, print them, and then make sure, again, the healthcare power of attorney, mental health power of attorney, and living will all require either a witness or a notary. The pre-hospital medical directive, also called a do not resuscitate order, has to be on orange paper and has to be witnessed by a healthcare professional. So you can't do that at the lawyer's office and you can't just have your neighbor witness it. It has to be signed by a healthcare professional. So for financial powers of attorney, that would be so financial power of attorney and guardianship or conservatorship kind of go together. for lack of a better description, because that's about the money. So conservatorship is over making financial decisions when we don't have a financial power of attorney, the agent is acting badly, or we don't have an agent willing to serve. And so then it's the court appointing somebody who could still be your family member to make financial decisions. But a financial power of attorney doesn't require accountings to the court, typically doesn't require a bond. Um, the problem with it is it's not always honored. For those of you who may have had a loved one who has had some challenges and you're trying to get access to a bank account with that financial power of attorney, sometimes the banks say it's too old, even though the statute doesn't require it be signed within a certain period of time, even though the power of attorney doesn't say that it expires at some point. They may say that it doesn't have the bank account number on it, or it doesn't say the name of the bank on it, and that that bank has its own form. So if you have a financial power of attorney, I strongly recommend that you bring it to the places that will need it in the future. So not assets that have a trust on them, but let's say you have a retirement account, to present it to the retirement company and say, hey, if I became incapacitated, is this going to work? Are you going to have an issue with this when my agent goes to use it, whether that's tomorrow or in 10 years? Um, because if they require that you sign a new document that's on their letterhead, you will have done that. And so you know that you'll be okay and that your document will work when you need it to work. One of the advantages of a trust, again, you can't put an IRA in a trust, but for other assets, are that every financial institution has a trust department. And so I've never had a trust be rejected, as long as it was valid, signed, and typically notarized, although not required to be notarized. Um, I've never had them reject the trust and say that the trustee can't access those funds. So just be conscientious to make sure that it's actually going to work. And for the healthcare document, you can also put in your healthcare document information about whether you want to be cremated or buried, whether you want to be an organ donor. Um, and so that's also important because it gives information. If you don't put in your healthcare document about cremation or burial, then remember there's a hierarchy and your spouse has the right, and then a majority of your kids, and down the line. So if your kids maybe don't get along or you're out of touch with one of them, that may cause a problem. Even if you've prepaid for it, they still need somebody to consent to that action. So let's talk a little bit about what I think your next steps should be so you can start thinking about a plan. You're going to want to kind of write down what your goals are, what your objectives are. Who do you want to get your stuff when you die? Who do you want to be your decision makers for financial decisions as well as for medical decisions when you can't make those decisions for yourself? Put together an inventory of your assets and your debts so the person who's going to take over knows what they're looking for. You know, it's not super helpful to find out that you're the financial power of attorney and you have no idea what accounts this person has. So I think the easiest way to do that is just print off the most recent statement from each place you have money, along with the beneficiary forms for your life insurance, annuities, and retirement accounts. Put everything in a binder. And so you can say to the person, hey, I have a blue binder in my office. That is what lists all my assets and all my debts. And that way, when you open or close an account, you can take papers out or put them in. Very easy to do. I know it's really low tech, but it's worked for this whole time. And you haven't put something on the internet that somebody could then find and potentially scam. So I think it's a good plan. Figure out who you need for your professionals, whether that's a financial advisor or a CPA, somebody to talk about life insurance or long-term care insurance with you, maybe an attorney to help you put together your legal documents. And then, you know, work on getting some documents prepared. I gave you a free website for all of your healthcare documents so that you could make sure that those are all done. They're easy and they're fillable and they're free. There's no reason anybody over 18 should do without those documents. I really do think they're that important. And one thing to really think hard about is to check your beneficiary designations on your retirement accounts and your life insurance and your annuities. This is an opportunity to kind of pull your information together, whether you ever go forward with doing a will or a trust or not, but for you to understand, what did you set up? What will happen to your stuff? Who will be making decisions for you? It's your opportunity to pull that information together and make sure it's what you want. Maybe you have an old life insurance policy and you have your deceased spouse or a parent on there. So this is your opportunity to get that information updated. You took the time to watch the video here today, so I know that you're motivated to get something done or to make sure that what you have is sufficient. So this is the time. I would encourage you to check the title on your accounts to make sure that those accounts are set up the way that you want them to be set up, that they're titled appropriately, and that you have, you know where all your money is. I know that sounds really silly, but sometimes people forget where they had funds. You can always check unclaimed property yourself and see whether you did forget about something. And now there's money that was deposited on your behalf. And so you can look for that as well. So I hope that I have given you some piece of information that maybe you didn't have when we started the webinar. I don't see any questions from anybody or any other information in the chat session. Again, my name is Emily Kyle, and so please feel free. I hope to hear from you. I so appreciate your time and energy today, and I hope that you stay well and that your families are well. And again, I just thank you so much for participating. So we look forward to hearing from you, and we'll talk to you soon. We have another webinar next month, so check out our website and you'll be able to see what's coming up. And so we got a couple of questions in. It says, if I would like you to do my trust, do I have to make an appointment in person? So I think I've only seen 3 people in person in my office since March. We are doing Zoom meetings, FaceTime, over the phone. If it's important for you to come in, we will, of course, follow all of the safety standards with masks and hand washing and staying far apart from each other in the conference room. So you would just contact the office and so anybody can make an appointment for you. We have a questionnaire we send out in advance. One of the things that's a really common question that comes up a lot is, what do I do with my estate planning documents? And so I would say, don't put them in a safety deposit box, because maybe nobody will know where that is, or they don't have the key. They're not a signer on the box. So make sure you have your documents in a place that is accessible. Make sure you tell the people who are your agents and trustees where the documents are. I suggest you give your healthcare power of attorney and living will to the people you've nominated. So if the emergency happens, they don't have to get to your house and try and make a copy at that point, but that you've already provided the copy to them. And if you are guardian for a loved one, you should put a copy of your letters of appointment in your glove box of your car, so that if the bad thing happens, you always have the document with you. And you might want to put your healthcare power of attorney in the glove box. And then maybe the police would find it if a bad thing happens, or if you're on your way to the emergency room, you would have it right there. So hopefully those are useful tips for people. Let's see. A couple of more questions. Is there any site with a trust, or is it dependent on the goodwill of the trustee? Oh, oversight. I'm sorry, I misread that. So the trustee, when your trust becomes irrevocable, is required to provide accountings to your beneficiaries, which should be the oversight. You can also nominate a trust protector in the document. That would be somebody who has a right to accountings anytime they request them. And so you can do that, but I hope you've chosen a trustee that you trust, because you don't want to just pick just anybody. Follow-up question is, can I do an in-person appointment? And the answer is yes. Again, we're doing as much virtual to keep everybody safe as possible, but I will see you in my office if that's important to you. For the cost, by all means, just call the office and we are happy to quote fees for you, understanding that there are ranges and flexible depending on what your needs are. But we do our estate planning on a flat fee basis. So once we had that initial consultation, I would be able to provide information exactly as to what the cost would be. And with that, I think I've answered everything, and I think we are at the end of our hour. So, again, thank you so much for staying. Thank you for your participation, and stay well. And I look forward to talking and working with you soon. All righty. Bye bye.